Okay, so let's start. Good afternoon and welcome to our webinar dedicated to the intellectual property and the Olympics and Paralympic Games of Paris 2024. For those who do not know Novagraaf, we are a company part of Questel Group. Novagraaf is an IP firm handling IP portfolios for numerous companies around the world. My name is Erika Winogradsky and I am a trademark and design attorney. Today, we are hosting this webinar dedicated to the Olympic Games and IP in order to show you the do's and don'ts in terms of trademarks and communication when you are not an official partner of the Olympic Games. Do not hesitate to ask questions during the webinar. We shall address them at the end. The webinar is recorded and we will send you the presentation afterwards. So let's begin. The Olympic Games are one of the world's biggest sporting events, and the opportunities in terms of media exposure are tremendous. 15 million spectators are expected, 15 million TV viewers are also expected. Everyone wants to enjoy this exposure. Yet, the budget of the Olympic Games, near 4.4 billion euros, is almost entirely financed by private revenues. 1/3 by the International Olympic Committee, 1/3 by the partners, 1/3 by ticketing, hospitality, and licensing. It is therefore imperative that Olympic properties are protected so that they do not lose their appeal to partners. So today we will discuss about the Olympic properties. What are they? We will discuss about the partners, who is allowed to use them. We will discuss, of course, about the legal framework. And then we will conclude with the do's and don'ts in terms of intellectual property and the Olympic Games. The Olympic properties. Here are a few examples. First of all, you all recognize the Olympic rings. Here is the emblem of the Paralympic Games. These are the most known Olympic properties. But one must know that words are also considered as Olympic properties, such as Olympic Games, Olympiads, in French, Olympique, Paralympic, Olympians, the Olympic flames. These are just examples. Other types of Olympic properties can be cited. For example, for Paris 2024, the motto is Ouvrons grand les jeux, pardon. The flame, the torch, is also considered as an Olympic property. Of course, the images of the Olympic Games are considered as an Olympic property. The logo of each edition of the Olympics, here is the logo for Paris 2024. The medals are also Olympic properties. What is less known is that the font used for each edition of the Olympic is also considered as an Olympic property. For example, here you have the special font used for Paris 2024. And finally, we can mention the pictograms that are used within the Olympics here at the bottom of the page. So now, what is the scheme of the Olympic movement for the management of these Olympic properties and their protection? First of all, we must say that the ICO and the IPC are the owners of the Olympic properties. They delegate the management and defense of the Olympic properties at the national level to the national committees in normal times and to the organizing committees of the Olympics during the Olympic periods. So for the Paris 2024 edition, the OCOG of Paris 2024 is in charge of the management and of the protection of the Olympic properties. They are in charge of this since the 1st of January 2019 and until the 31st of December 2024. The organizing committee is dealing with the commercial partners, the licensees, and the media partners for the Paralympic Games. The media partners for the Olympic Games are still handled and remain handled by the ICO. The partners, who are they? For this edition of Paris 2024, here they are depicted on this slide. You can see there are various categories: worldwide partners, premium partners, official partners, and official supporters. Several categories depending on the amount of the investment made by these partners for the Games. These partners, in exchange of their participation, in exchange of their investment, are given the authorization to use the Olympic properties. Let's talk now about the legal framework and first of all of Rule 7 of the Olympic Charter. The IOC is the owner of all rights in and to the Olympic Games and Olympic properties described in this rule. The paragraph 4 of this rule is defining the Olympic properties. So the Olympic symbol, the flag, the motto, the anthem, the identifications, the designations, the emblems, flame and torches, and any other musical works, audiovisual works, or other creative works or artifacts commissioned in connection with the Olympic Games are owned by the IOC. In addition, when it comes to French law, it must be noted that the Olympic properties are protected through trademark law when they are registered as trademarks. The French Intellectual Property Code states that it is an infringement to reproduce or imitate a trademark for goods or services identical or similar to those covered by the application. The same code sets out the applicable penalties, which can include up to 4 years imprisonment and a fine of 400,000 euros. Here are some examples of the trademarks registered by the Olympic authorities. Of course, we have the Olympic rings. Here is the logo for Paris 2024. We also have several associations of the name of hosting cities with the year. Here, for example, Los Angeles 2028. Several versions of torch and flames associated with the rings, here and here. Here is the logo for Beijing 2008. And we also have a few registrations for posters of the Olympics. Here is an example for the London edition of 1948. One must also note that several Olympic properties have been recognized as well-known trademarks according to the French Intellectual Property Code, and they are protected no matter if they are registered as a trademark or not. This is the case, for example, as Jeux Olympiques, JO, Olympic, and of course, the Olympic rings. In addition to this protection by trademark law, the Olympic properties are also protected by specific legal provisions of the French Sports Code. This article reminds us of the definition of the Olympic property in the first paragraph. The second paragraph explains that the act of registering as a trademark, reproducing, imitating, affixing, removing, or modifying the elements and terms mentioned in the paragraph 1 without the authorization of the French National Olympic and Sports Committee is punishable by the penalties set out in the French Intellectual Property Code. Same provisions are also available for the Paralympic properties. So what does this mean? Here we have a reference to the provision of trademark law resulting in an extraordinary protection of the Olympic properties conferred without any registration as a trademark. In a nutshell, all the Olympic properties, no matter if they are registered or not, are protected against infringement acts and without having to examine the existence of a possible risk of confusion. In addition, we will just mention that all Olympic properties may be protected by author rights and design rights. We will not discuss this in details today, considering the limited time we have together. However, what we can say at this point is that all rights to the elements created in the context or for the purposes of the Paris 2024 Olympic and Paralympic Games are the exclusive property of the Olympic authorities. So once we have said that, what can you do if you are not a partner of the Olympic Games? What are the do's and don'ts of the Olympic Games and intellectual property? First, in terms of trademark registration. Here, there are two major obstacles to be mentioned. First, trademarks can be refused ex officio by the French office. Second, the trademarks can be refused following opposition lodged by the Olympic authorities. Regarding the ex officio refusal, the French office refuses trademarks on the basis of the French Code of Sports. For example, the trademark applications for Olympic 2024, Olympico, Olympe Coaching, Le Petit Olympien, Olympiade des Sciences de l'Ingénieur, Bazar Olympiade, and this King Paris 2024 have been refused. Once again, as said earlier, there is no analysis of the risk of confusion. So no matter if these trademarks were not considered as confusing with prior Olympic properties, it does not matter. As long as there are Olympic properties existing, these trademarks are refused based on the Code of Sports. If by extraordinary your trademark application does not face any refusal and is still published for opposition, you risk having to face an opposition lodged by the Olympic authorities. So, for example, Paris 2025, Paris 2024-2025, Normandy 2025 have been refused based on the existence of prior trademark Paris 2024. Likewise, the trademark application Vivons 2024, which means Living 2024, has been refused on the basis of prior trademark Partageons 2024, which means Sharing 2024. Other example, Olympic Battery, Electrolympic, Olympida, Olymp Events, Gerolymp, and Paris Cycliste Olympique have all been refused following oppositions based on Olympic trademarks. So what are the do's and don'ts? Well, first, don't use variations of the word Olympic or related term like Olympic Games, OG, Olympiads, etc. Do not use the name of an Olympic city in association with an Olympic year. Paris 2024, Los Angeles 2028 is prohibited. Do not use a year in association with a term close to those used by the Olympic authorities. This is the case of Vivons 2024 against Partageons 2024. And finally, do not use terms or logos close to those used by the IOC, the IPC, and the OCOG. What to do then? You must contact your designated IP expert for an in-depth clearance. Your IP expert will be in a position to analyze the risk of rejection of your trademark and the risk of infringement of Olympic properties. Let's talk now about advertising. The do's and don'ts are almost the same as for trademark registration. Do not use the variation of the term Olympic or related terms. For example, do not use the Fashion Olympics, the Insurance Olympics, the Real Estate Olympics. This is very tempting, but this is not possible. Do not use the name of an Olympic city as a promo code or as a hashtag. This is not permitted either. Hashtag Paris 2024 is prohibited. Also, do not use terms or logos close to those used by the IOC, IPC, and OCOG. One very trendy use is to hijack the Olympic rings. Do not do so. This is not permitted. We will see examples later, but for now, what I can say is that it is not permitted. So what to do? If you plan on releasing an advertising campaign, beforehand, contact once again your designated IP expert who will help you evaluate the risks. In addition to being vigilant about Olympic properties, it is important to pay close attention to the communications involving athletes and their image. It can be tempting to show our support or congratulate our athletes. This is possible under certain conditions laid down in Rule 40 of the Olympic Charter. The Rule 40 of the Olympic Charter sets out the principles governing the use of the image of participants in the Games for advertising purpose during the Games. So during the Games period, advertising and/or publications must comply with the following conditions. Obtain the consent of all parties. Do not indicate explicitly or implicitly that a particular product or service has helped to improve the participants' performance. Do not show personal support for a particular product or service. Respect the policies of the IOC, the IPC, the CNOSF, CPSF, and Paris 2024, which define activities that are incompatible with the values of the Olympic and Paralympic movements. What does this mean, to be more precise? For non-Olympic and Paralympic partners, outside of the game periods, non-Olympic and non-Paralympic partners who have signed a personal contract with an athlete are free to use the athlete's image under the condition of the signed contract, of course, on the condition that they do not use the Olympic or Paralympic properties. During the game periods, the non-Olympic and non-Paralympic personal partners are still authorized to use the image of the participant for advertising purpose. If this ad does not contain any Olympic or Paralympic property, and if this ad constitutes a generic advertisement. So what is a generic campaign, a generic advertisement? Generic campaign means any advertising for a brand or a company whose only link to the games is that the said advertising uses the image of a participant. This campaign was already broadcast at least 90 days before the games periods and was sent to the CNOSF, the CPSF and Paris 2024 on the dedicated platform no later than the 18th of June 2024. And finally, the broadcasting of such campaign must be regular and must not increase considerably during the periods of the game. The games period for this year's edition are as follows. From the 18th of July to the 13th of August 2024 for the Olympic Games, and from the 21st of August to the 10th September 2024 for the Paralympics Games. The participants, the athletes themselves, may also participate in the promotion of their non-Olympic and non-Paralympic personal partners. Outside the game periods, they are free to do so, as long as they do not use the Olympic properties. During the game period, they are allowed to do so by means of one thank you message per partner in French on the participant's personal social network account or website, and of course, without use of Olympic or Paralympic properties. So here are two examples of communication. On your left, a communication which does not comply with Rule 40. It does not comply with Rule 40 because it uses Olympic properties. You see the reference to the Tokyo city, which was a hosting city, the reference to the games. Therefore, this is not compliant with Rule 40 of the Olympic Charter. On your right, on the contrary, we have a communication which is compliant with this rule. This is a simply congratulatory message. It uses neutral image without use of any Olympic property. And the message is quoting the partner, but without any mention of the Olympic properties. For the official partners, everything is easier. They are free to use the image of the athletes with whom they have entered into a personal contract for advertising purposes and to broadcast congratulatory advertising messages during the periods of the games, under the condition, of course, of the contract of the Olympic or Paralympic partner concerned. Athletes are free to promote their Olympic and Paralympic partners and to send them message of thanks. What does this mean? Here are two Instagram posts by Le Coq Sportif. Le Coq Sportif is an official partner of the Olympic. And they published on Instagram these two posts. You see here that they used several Olympic properties, Jeux Olympiques, Paris 2024. They use the logo of this edition. They use the pictogram here and here. And they use, of course, the image of the athletes they are sponsoring. Everything here is allowed because they are official partners. So this means that if you're not an official partner of the Olympic Games, this is everything that you cannot do. Let's talk now about ambush marketing. Ambush marketing consists of positioning oneself in the wake of a sporting event, in particular the Olympic Games, and taking advantage of the investments and efforts made by the official partners. Articles 1240 and 1241 of the French Civil Code are applicable to such behaviors known as parasitism. Here are a few examples of don'ts. So do not use the Olympic properties on printed or digital media. This means no bill posting near stadiums. If you're not an official partner, if you do not have an authorization by the Olympic authorities, do not bill post near the stadium using the Olympic properties or elements that remind one of these Olympic properties. Do not issue press release, do not issue magazines destined to the public, do not distribute goodies with the Olympic properties on them, and do not post on social media. One famous example of ambush marketing in the history of the Olympics occurred in the London edition of 2012. The Beats brand supplied several Olympic athletes with headphones, including Michael Phelps, Olympic champion for swimming. And this gave a considerable media exposure to the Beats audio headphones. All the while knowing that Beats was no official partner and did not invest in the Olympic Games. This type of behavior can be punished on the grounds of parasitism. For example, the following behavior have been punished under French law as constituting acts of parasitism. First of all, here, publication on social media of two posts, En route pour les JO d'hiver Pyeongchang 2018 and Si tu vas à Rio, with the depiction of a stylized flame, using also the color of the Brazilian flag. This was considered as a violation of the French Code of Sports. This was also considered as an infringement of the well-known trademark JO. And finally, this was considered as parasitism of the Olympics. Likewise, This promotional banner published by Pixmania during the Olympics of Rio 2016, mentioning des deals en or, golden deals, using the terms Jeux Olympiques, using shapes resembling the Olympic rings, displaying here the Corcovado, were considered as parasitism. Another decision involving company Master Distribution and UFO, and regarding the sale of polo named Rio 2016 and the use of hearts depicted as the Olympic rings using the same color and same position in association with the name of the hosting city, Rio. Here we have found several examples on the internet of behaviors that could be considered as ambush marketing. On your left, an advertising for condoms. Condoms are displayed with the colors and with the same positioning as the Olympic rings. This is not permitted. Likewise, in a supermarket maybe, or maybe a shop near a stadium, we don't know exactly where it is, but they decided to install their packs of sodas, also depicting the Olympic rings. This also can be considered as ambush marketing, so one must pay attention. Okay, so we have reached the end of this presentation. We'll see if we have any question now. Are generic phrases such as "let the game begin" a part of Olympic and Paralympic branding property, and are there legal rules and regulation around using this tagline as a part of a brand campaign? Well, yeah, as we said earlier, using elements that reminds of the Olympic properties, even if they are not Olympic properties themselves, can be considered as parasitism. So let the games begin, used during a period of the Olympic, would probably raise difficulties. Okay, so no other questions? Okay, this is time for me to address special thanks to Elena and Laura, who helped me prepare this webinar. We'll also address a big thank you to Romain Voillemot, General Counsel of the Organizing Committee for Paris 2024. He was present this morning during the presentation in French. He gave us many insights and advice, so a big thank you to him. And now let me wish you a very good end of the day. See you. Bye-bye.